Good morning. My name is David Birch. I'm from Morris, Manning, and Martin in town, and this is How to Buy a Commercial Building. First, a little bit of information on Pro Bono Partnership of Atlanta. As you'll see the mission statement on the second slide of the presentation, it is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. If you have any, or the eligibility information for pro bono partnership clients is on the third slide. If you have a need for specific legal service, please refer to that slide and your eligibility compliance. Or if you have a question, there's contact information for pro bono partnership personnel on that slide as well. On the third slide, I just want to point out to you that this presentation is not intended to be specific legal advice, but rather just general information on how to buy a commercial building. If you have a need come up with to buy a building, please contact Pro Bono Partnership and they will engage someone to represent you on that specific need. Starting with the meat of my presentation is on slide 5. Just some initial considerations for anyone who's interested in buying a building. First, think about your budget. Understand that you're going to have to pay interest on your building if you're going to take a loan on it. Understand costs incurred in owning a building versus rent, maybe operating expenses you're not anticipating, maybe utility costs that you're not used to paying or paid through your rent otherwise. There may be HOA fees, which we'll get to in a little bit when we talk about title. So just consider your budget and all the things that need to go into it as you decide whether or not buying versus leasing makes sense for you. Next consideration is, do you have a building that fits your needs as is, or have you found one? Or do you need to actually construct the building? Construction costs can bring in a myriad of issues, or I should say construction can bring in a myriad of issues, including unknown costs, zoning, impact studies, etc. So just understand those are out there when you're making that decision on whether to build or buy an existing building. Third is the mortgage question. One, it's relevant to pro bono companies, or I should say nonprofits, is it permitted by your bylaws or your governing documents? For-profit companies will almost always mortgage for the ability to leverage their limited capital. That's a different equation, of course, for nonprofits. So consider that. Understand that a mortgage is a hard obligation to repay money. The fact that you're a nonprofit does not exempt you from that obligation to the bank. In the recent downturn, I had several clients who had issues with personal obligations on mortgages, thinking that they would just be able to give the property back and the remaining loan balance would essentially be forgiven. But instead, that balance continued on. So understand that you are taking on a significant risk in deciding to borrow money. So just a consideration. Third or fourth, ownership entity. Often for-profit clients will form a LLC subsidiary to be a shell entity to own the property to shield the parent company from liability. This may or may not be allowed or I should say, when you make this decision, make sure you consult with pro bono partnership or attorney regarding tax exemptions that may be eliminated if you form an LLC to hold the real estate. It varies in Georgia and other jurisdictions, but something to consider. But otherwise, from a liability shield standpoint, there are bonuses or benefits to doing so. So just something to consider initially. Once you've considered those factors and others with your attorney, you'll get to the stage of actually negotiating and signing a purchase contract. The purchase contract is more important in a commercial building acquisition context than your typical residential purchase that you may all be familiar with. Whereas residential purchases are almost always as is, where is, and it's buyer beware. The diligence obligation is on the buyer. In a commercial context, you can expect to get some assurances from your seller as to qualities or compliance of the property with certain laws, etc., that you can rely on and essentially sue for or seek damages for if those turn out not to be true after you purchase it. So through your attorney, you'll negotiate certain representations and warranties from the seller, such as the property is in compliance with zoning, there are no known defects in construction, there are no outstanding HOA dues on the property, etc. And if it turns out after you buy the property you discover that any of those things are false, you'll have a contractual remedy or a right to enforce against your seller, whereas in a residential context, you're typically just stuck with it. So things that are important to negotiate in the purchase agreement. Other things, if there's a specific issue with the property, maybe you're aware of a particular environmental concern, or there is a repair that everyone knows needs to be made and the seller has agreed to do it after you close on your acquisition, you may negotiate a holdback of the purchase price, meaning I'll buy the property for X, but I'm going to hold back 10% of X until this one condition is satisfied to my reasonable satisfaction. So that's something to consider. Third, there may be an issue that you're particularly concerned about, and therefore you want to extend or have the ability to extend what we call the due diligence period before you're able to resolve that issue. So let's say that there was an environmental concern that was supposedly remedied 10 years ago, but you're not able to fully diligence that in the stated 30-day due diligence period in your contract. You may want to negotiate a right for a unilateral extension for another 30 or 60 days to allow you to continue that diligence without having to go back to the seller and get their consent or potentially make an additional deposit, etc. So just all things that could come up in negotiating your purchase contract. The next slide lists diligence considerations by general category. The first is title and survey. Title and survey essentially can confirm that you're getting the property that you think you're getting, and there are no other rights in the property that you're not aware of. So your title report is essentially a list of all the things of record that encumber or affect the property. This is something you'll order within a few days after signing your purchase agreement. It's handled by, there's several title insurance companies that will handle it. It's a fairly routine process. And the title report will list everything that affects it. It could be easements to the utility company, which are generally fairly innocuous. It could be, there could be covenants against or containing restrictions on what you can develop on the property or how you can use the property, which can be fairly more involved and require more analysis from your attorney. There can be declarations or community covenants that require payments of assessments for common area maintenance and insurance of common areas within the development, which may impose additional costs of ownership that you might otherwise not be aware of. So title is a very important element in your diligence process, and the survey will depict any of those title exceptions which affect a particular area or portion of the property, such as an easement area or building height restrictions. The survey would measure the building height and confirm or point out if you don't comply with the building height restrictions, things like that. Environmental, another vital area in your diligence process, because in the U.S. it is strict liability for owners of commercial property, i.e. the owner is liable for the environmental compliance and cleanup regardless of whether the environmental issue was caused by the owner. So generally the first step in environmental diligence is called a Phase 1 environmental site assessment. The Phase 1 is a search of environmental records, a site visit by an environmental engineer, and a report on all of their findings. If you're lucky, and it's not all that atypical, the Phase 1 will reveal no environmental conditions, and you'll consider that to be sufficient diligence. But if there are any, then we'll recommend additional testing, which can be time-consuming and costly, and again, maybe a reason for you to negotiate a unilateral extension of your diligence period in your purchase contract. Just to give you an idea on cost, Phase 1s generally cost between $3,000 and $5,000. But in the event they turn up a problem that will save you many, many more thousands, they are very worth it. Also, if you plan to get a mortgage on a property, a lender will require a Phase 1. It's required for any FDIC insured lender to get a phase one on mortgage property. So a cost you won't be able to avoid in a mortgage context. Third element of good diligence is zoning. Just because a building is used currently doesn't mean you can use it the same way, or just because a particular use is currently occurring at the building doesn't mean it's legal and doesn't mean that you can use it that way. So zoning is a search of the municipal code related to use, height restrictions, parking restrictions, setback restrictions, etc. on a particular piece of property. There are several zoning research firms that will prepare or can prepare a comprehensive zoning memo on any piece of property, generally for between $600 and $800. Most lenders, again, will require this on a commercial building, so it's a cost you likely will incur if you're going to get a mortgage. But it can save you a big headache down the line in the event that the property use is not compliant or you intend to build or expand on a property, to know the limitations for that expansion or construction. Last diligence category, lien searches on the seller. You never know if a seller has pledged or essentially mortgaged its ownership interest in the property. So if an LLC owns property and then two individuals own that LLC, it's possible those individuals have pledged their ownership interest in that LLC for additional indebtedness, and that lender may have restrictions on their ability to sell the property that wouldn't show up in title. So a lien search on the seller entity itself is something that can head that off or prevent that risk for you. Okay. Before we move to the next slide, I didn't put this on a slide, but something that should be mentioned is once you've cleared all the diligence hurdles and you're satisfied with that the property meets your requirements and you're ready to close, I would advise any client to obtain a title insurance policy. It is the final product of the title search process, and it is an insurance policy against any claims in that property that aren't listed on your title insurance policy. So someone comes out of the woodwork 3 years after you purchased it and says, I actually own 20% of this building, the title insurance company will insure you over that, assuming that person's interest isn't of record and listed in your policy as an exception for coverage. So they're generally priced at about $1 per $1,000 of coverage, so they're not terribly expensive, and they're just comfort that you understand and are insured as to your interest in commercial building. The next slide are tax considerations. I admit I am not a tax attorney, so when this stage in the process comes up in your acquisition of a building, you will need to engage pro bono partnership to talk to a tax attorney. But things to consider, and I've had come up in these situations in the past, are possibly a seller would be willing to give a lower purchase price and able to realize a tax deduction on the difference in the fair market value versus what they're willing to sell it to you for. Also, your diligence providers may give you a discounted rate because of your 501c3 status and their ability to write off their services as a charitable contribution. So just things to consider as you go through the diligence process, and things your attorneys can advise you on. For any more information on this topic or others, slide 8 contains the pro bono partnership contact information. Any questions to answer? Okay. We have a few questions.
Just to thank you. Oh, yes. We have one question. asking whether or not the property can be donated, but there has to actually be consideration for it?
That sounds like a consideration question. Oftentimes in a contract, parties will put in a nominal amount, $1. It used to be $1, now it's increased to $10 just to account for inflation, I suppose. But to satisfy a general requirement in contract law that what or I should say the buyer would require that they give the purchase contract state $1 or $10 of consideration given to the seller, just so that the seller can't come back later and say, actually, this contract's void because there's no consideration given to me for my decision to convey the property. I think it's, again, just a nominal amount. It's not really intended to be a negotiated point. The deal is a charitable contribution and a conveyance of property, but the $1 or $10 of consideration is just a matter of satisfying a nuance in contract law.
How much should one budget for the due diligence and title review process before a contract is finalized?
Good question. Let me go back to my due diligence slide just so I can give you a good idea of the entire budget. A title search generally costs between $350 and $700 depending on the jurisdiction. If it's a major metropolitan area like in the city of Atlanta or any of its metro counties, the county records are fairly well organized, and so the search will be on a lower end. If it's a remote jurisdiction, the search may be on a higher end. But a title search, production of a title commitment, is generally between $350 and $700. Survey costs can vary greatly depending on the size and scope of the size of the property and the complexity of the development. If it's just a single warehouse, for instance, or 5,000 square foot office building, a survey would cost you between $1,500 and $2,500. We talked about the environmental phase 1 costs. Those are generally $3,000 to $5,000, and zoning between $600 and $800. So all in, you're looking, if you include the phase 1, which you may not if you're buying it without a mortgage, and maybe the seller has an older phase 1 environmental report that you can get comfortable with. If you omit the phase 1, you can get in for less than $2,500 in diligence costs.
Now, that doesn't include attorney's fees, and for pro bono clients, our clients, it's free.
Right.
But those are out-of-pocket expenses.
Those are out-of-pocket expenses to diligence firms, so the title company, the surveyor, the Facebook. Now, if you have to pay an attorney to review these things for you, of course, that can add on a significant amount. Through my engagements with Pro Bono Partnership, we've reviewed those, of course, and that cost is free or given on a pro bono basis. Okay, well, that's all the questions. Thank you for allowing me to present to you. And oh, wait, no, just under the wire.
It's too specific.
That's all of the questions that we're allowed to answer today. So if you have a specific question about potentially purchasing a building, please contact Pro Bono Partnership, and maybe we'll get to work together someday. Take care.